Hi, I'm Ronelle Bridge from CTX Special Risks, your most dedicated marine insurance broker for both ship owners and charterers alike in Asia. On the 23rd of March 2021, the container ship Ever Given grounded in the Suez Canal, temporarily blocking one of the busiest waterways in the world. In the 6 days that she remained stuck, more than 400 ships had become stranded, resulting in damages in the billions of dollars. In part 1 of my video, we focused on charter parties and we looked at the likely disputes that will flow from that contract. Today, in part 2 of this video, I want to focus on another important shipping contract, the bill of lading. What type of cargo claims can owners expect to receive from cargo receivers under their bill of lading? And what kind of arguments and defenses can they consider, or steps can they take to recover some of their losses? Let's look now at bills of lading. What if I receive claims from cargo receivers due to the delayed delivery of the cargo under my bill of lading? And here I would like to divide it into 2 different categories: physical damage to cargo and pure economic losses. Let's start with physical damage to cargo. And here I'm specifically talking about agricultural products, perishable cargo, reefer cargo, which will inevitably have a shorter lifespan now that the cargo has been significantly delayed in transit en route to the discharge port. To the extent that a ship owner is found liable in any jurisdiction for such types of physical damage to cargo, I think this will be considered by P&I clubs as a normal P&I claim, which should be covered, but my colleagues will discuss in more detail recovery claims under insurance policies. The more tricky question is that of economic losses. If a receiver submits a claim for pure economic losses, will a ship owner be held liable for these type of losses? Let me first explain what I mean by a claim for pure economic losses. This is a case where there's no physical damage to cargo. So the loss lies in market fluctuations or value of the cargo at the time of delivery of the goods at the discharge port. Will a ship owner be held liable for these type of market fluctuations? Under English law, these kind of claims are difficult to prove. The Hague Fish Bureau Rule, Article 4, Rule 2Q, I believe it is, specifically says that any losses caused without any fault on the part of the ship owner will not be claimable, and a ship owner will not be held liable for those kind of losses. But what about other jurisdictions that do not recognize the Hague Fish Bureau rules or have other local laws? For example, I can think of China, where a claim for pure economic losses is commonly claimed and ship owners are frequently held liable for these kind of losses. To the extent that the ship owner may be held liable for pure economic losses under these other jurisdictions, all may not be lost. There is a possibility that a ship owner can claim their charterer under the implied time charterer indemnities imposed under English law. This, of course, assuming that the time charter between owner and charterers is governed by English law. So now that I have identified a few of the losses that will likely flow from this incident, I just want to spend a brief moment on considerations on whether or not you could potentially claim the owners of the Ever Given for some of your losses. My preliminary view is that this type of claim might be difficult for the following reasons. The first is you have no contract with the ship owner of the Ever Given. Therefore, your claim will have to be based in tort. We would have to look at the local laws of Egypt as the country or the jurisdiction in which this incident occurred to establish whether or not they recognize claims in tort and what kind of evidence is required to succeed with such a claim. Now, a normal element of a tort claim is that of negligence or fault. Investigations are still ongoing and more will be revealed in due course, I'm sure, but at the moment, a sandstorm and bad weather is blamed for this incident. So far, there has been no suggestion that I am aware of any fault or negligence on the part of the Ever Given, and therefore a claim in tort may not be possible. The second concern I have is that of enforceability. Even if you are able to obtain a judgment in Egypt, which are normally considered very lengthy court proceedings and rather expensive, at the end of the day, can you translate the successful judgment into money? Will the ship owner still have an asset at that point in time for you to arrest or to sell in order to recover some of your losses? I think these are important considerations which will only be revealed in due course. At the moment, it is interesting, however, to think about these aspects, and I'm sure lots of these will be hotly debated between yourselves internally in your office. If there's anything you would like to discuss with me or send me some feedback on this video, what have I missed? What would you like me to explain in more detail? Or would you like me to review a specific case on the basis of your specific time charter party or voyage charter party clause wordings? Please do get in touch. I'm here to discuss with you, and I look forward to hearing from you. This brings us to the end of part 2 of my video. Thank you for watching. Meanwhile, do you have any questions, or would you like me to consider your specific case in more detail? Do get in touch. I look forward to hearing from you, and stay tuned. In part 3, the last of my videos on the Ever Given grounding, I will look at the implications this incident will likely have on your marine insurance policies.